What happens at a change of plea hearing in federal court? That is a very big day for criminal defendants. That is a very big day for clients. That is the day when the client comes in and says, Judge, I want to change my plea. I'd like to go from not guilty to guilty. Sometimes you do it pursuant to a plea agreement. Sometimes you just plead open with the judge. Ultimately, the judge has several functions during this proceeding. The judge needs to know that you understand what you're doing and the rights that you're giving up, and you're competent to do so. The judge also needs to know that your attorney has done his job in talking to you and going over the case, that you spent enough time talking about, do you go to trial, do you take the plea? And the judge also needs to make sure that the prosecutor, and they typically do this by way of proffer, where the prosecutor just generally says what the evidence would have been at trial. The judge also needs to make sure that the prosecutor would have been able to establish the case against you at trial, and also that venue is proper in the district where you're taking your guilty plea. So overall, this process takes about 30 minutes. It's a very standard colloquy that judges do pretty much across the United States in federal courts. And it's a very big day, and it's a very big proceeding, because ultimately the client says, I don't want to go to trial. I want to resolve my case. And typically the client either has to rely on the prosecutor's version of events, or the client has to say in his or her own words what it is that makes them guilty. Typically, these are the elements of the charge. They track the indictment, and ultimately it's relatively a quick proceeding, but your lawyer should be prepping you for it.